Well, I guess let's get started. Welcome to the Iowa Ideas Conference and our session, Keeping Balance in the Judiciary, which is within our policy track. I'm your moderator, Tom Barton, Gazette Deputy Bureau Chief and Politics Reporter. A fair and independent judicial branch is a key piece of our democracy. That independence helps judges stick to the facts of the case and ignore special interest and partisan forces. Once hailed as a gold standard in judicial selection, there have been challenges in the judicial selection process. A significant wave of retirements that has meant that Iowa Governor Kim Reynolds has appointed a majority of the court. And a global pandemic has also impacted how the courts have done business. How is the court doing at managing against outside influences and working to preserve its balance? We'll explore that and more during this hour. Our time together will include talking with our panelists who you see here today and addressing audience questions. All of our sessions have closed captioning access and all of our sessions are being recorded. If you have questions for our panelists or would like to share your perspective, please submit it in the chat and we will do our best to get to as many as our time and discussion allows. So let's introduce our panelists. Joining me today are Iowa Chief Justice Susan Christensen, Iowa Bar Association President Henry Hamilton, Executive Director of Interfaith Alliance of Iowa and Board Chairperson for Justice Not Politics, Connie Ryan. Thank you all for joining us today. We really appreciate you taking the time.
Thank you.
Thank you.
Thank you, Tom.
We'll start with brief introductions. Chief Justice Christensen, I guess we'll start with you. Can you tell us a little bit about your background and connection to this topic?
Sure. First of all, thank you for inviting me to be a part of this panel. I've been a lawyer since 1991, and then about 15 years later, I became a judge. So I've been a judge since 2007. I started off as a district associate judge, which many people may think of that as a juvenile judge. That was a lot of what I did. I did that for 8 years, and then a district judge for 3 years. And then on the Supreme Court, I'm just starting my 5th term, a little bit over 4 years now. So the Judicial Nominating Commission is something that I am very familiar with. Some people might think I've only touched upon it 3 times since I've been in 3 judicial positions, but I've actually participated in the Judicial Nominating Commission 14 times. And I added that number up after I was appointed to the Supreme Court because I knew it was a lot. And I wanted people to know, hey, I say it, I got told no 14 times by either a commission and 3 times by a governor. So I am very, very, very well aware of how Iowa's Judicial Nominating Commission works. I think our merit selection process works, and it works well. And our judicial branch, as you stated, the judicial branch being independent is a critical piece of our democracy. And that's why I was excited to be a part of this today. Every county in Iowa has a courthouse, 99 counties. And in my opinion, coming from a smaller rural community, Shelby County, they are the crown jewels of our downtown. They are the crown jewels of our community. That and schools are incredibly important to everybody in a rural community. And it's true in the urban communities too. And the goal of my purpose as chief is to make sure that every Iowan that walks into our courthouses has an opportunity to be treated fairly and impartially, and that we can help them resolve their disputes in a way that allows us an opportunity to help the next person in line. So I'm proud of our judges. I'm incredibly proud of our court employees, and I appreciate this opportunity.
Well, thank you. A quick disclaimer and reminder for those submitting questions in the chat. Ethics rules limit what justices and judges may say about cases and issues. Judges may explain court procedures in general terms, but must abstain from commenting on pending and future cases. The purpose of this is to avoid the possibility that the comments of a judge would affect the outcome of a case. So Iowa Supreme Court justices do not explain appellate opinions or speculate about the impact of an opinion on the law. Again, this is to preserve the authority of the court's written opinion as law and to kind of avoid interpretations or statements that might conflict with or confuse the precise legal meaning of the court's opinion. So today we'll be focusing specifically on Iowa's merit selection process, court procedures, and how courts have conducted business during the pandemic. All right, now that that's out of the way, moving on, Henry Hamilton serves as president of the Iowa Bar Association. Welcome, Henry. Can you tell us a little bit about the work of the Bar Association and your connection to this topic?
Sure. A little bit about my background. I'm a 1988 Drake graduate, 1992 Drake Law School graduate, and I've had the privilege of this year serving as the 136th president of the Iowa State Bar Association. I first of all would like to thank you all and the organizers for inviting the Iowa State Bar Association to this important discussion. To piggyback off of what the Chief Justice said, a fair and impartial judiciary is indispensable in our form of democracy. And when I talk to people, I tell them that if you look at the Declaration of Independence, there's 27 grievances. 10 of those, that's more than a third, have to do with preserving the integrity of our courts and our jury system. And just so happy and thrilled to be here to talk about these issues. The Iowa State Bar Association, since 1962, when we started with the merit selection process, we've issued a judicial performance review where our attorneys actually rate judges in several categories, and we make that available to the public.
Great. And Connie Ryan, Executive Director of Interfaith Alliance of Iowa and Board Chairperson for Justice, Not Politics. Connie, welcome. Tell us a little bit about your work with those organizations and how they've been involved in this issue.
Certainly. Thank you, Tom, for the invitation to be on this panel and to be part of this great group of folks. I have been the Executive Director of Interfaith Alliance of Iowa. This is my 20th year. And in 2010, and we can get more into the details of this, but the court was attacked and attempts to take justices off of the bench, and that was because of one singular decision. Interfaith Alliance of Iowa works in the realm of civil rights and challenging extremism, and so it was important to us to be able to be part of the conversation of why a judiciary, fair and impartial judiciary, is so critically important in our democracy and in our state. And so we dove into the issues at the time and helped to create Justice, Not Politics, which is the main organization in the state of Iowa that is solely intent on making sure that we continue to have a fair and impartial court and that the merit selection system is robust and remains that gold standard. And we can talk some more about that and what that means as well. So we have Justice, Not Politics has been around for 12 years. Interfaith Alliance of Iowa has been part of that since the very beginning.
Great. Again, a reminder that if you have a question for our panelists or would like to share your perspective, please submit it in the chat, and we will do our best to get to as many as our time and discussion allows. So we'll start off with a little bit of history. In 1962, Iowa voters approved a constitutional amendment that replaced the unpopular process of selecting judges by general elections based on political party politics with a nonpartisan merit selection and retention process. Chief Justice, can you tell us a little bit about how this process works for selecting judges in Iowa? Who's involved and who makes the final appointment?
Sure. First of all, 1962 was a great year. That was the year I was born. So I know exactly, it's been in place now for 60 years. And so for 60 years, this process, as I stated, I probably could be qualified as an expert to testify in court about our process. But let me start at the district nominating level. That would be the state. That'd be the trial court. That's what most people are probably familiar with. And that the District Court Nominating Commission, there are 8 districts across our state. I'm from Southwest Iowa, for example. That is called the 4th. Des Moines is the 5th. The Quad Cities are the 7th. But anyway, you understand, there are actually 14 different judicial election sub-districts. Some of the districts, like the 5th, are very large and they have more than one. So those 14 sub-districts each have a commission. And when there is an opening, maybe retirement or death, or sometimes we even have statutory provision for perhaps maybe a new judgeship in a different part of the state. For whatever reason, the governor has been informed that there's an opening, we begin the process. And that process starts off with making application, and the application is pretty rigorous, but you send it to a commission that is made up of many individuals. At the district level, currently the chair of that commission is the most senior district court judge. Then there are also 5 members who have been chosen by the bar. That'd be the attorneys in that district, not just statewide, but that district. So it would be people voting for people they know. And then also there are 5 members in that area that have been appointed by the governor. So that makes 11. And the applicants, however many, there's a deadline set. Everyone submits their application. The commission sets a date for the interviews. And I just do want to comment how it has changed and evolved since I began the process. The first time I ever applied for a judgeship, there probably were 25 applicants. And it was winnowed down, of course, to 2 names that went to the governor. We have had some situations with as few as, I think the least I heard was 3, where 2 were going to go to the governor's office. So that has been a dynamic that has changed during my 14 times, is the very much a decrease in the number of applicants. So anyway, then those names go to the governor, the 2 names, and the governor has 30 days to make a choice of which person she chooses to be the judge in that spot. Those commissioners at the district level have 6-year terms. And oftentimes, I think the experience that they have many times, sometimes commissions haven't been very busy. Other times there have been a lot of retirements. So it just depends on what's going on in the district. There's another level of a nominating commission, the State Judicial Nominating Commission, and that commission is in charge of the Court of Appeals and the Supreme Court appointments. It is a bigger commission and it's handled just a little bit differently. Let me tell you what it was like when I went through. It was chaired by the most senior justice on the Supreme Court. There were 8 elected members by the bar, and that would be a statewide election because it's a statewide commission. And then there were 8 members who had been appointed by the governor. That has since changed, and there's no longer a judge sitting there chairing it. And that person is made up with a 9th person who is appointed by the governor. The people that the governor puts on the commission are confirmed by the Senate. The process is similar as it is at the district level, and actually it's become much more streamlined. The application is very similar at the state level that it would be for a district job, and it's really rigorous and detailed and in depth, and I think very interesting. But once someone fills out an application, I hope they try again if they don't get the job, because the application is a big chunk of the work. And you can't change your life story in just a few months. So hopefully it'll just be a little bit of updating. So at the Court of Appeals level, historically it has been, actually it used to be 5 many years ago would come out of commission and the governor would choose 1. Then it was changed to 3, and it was once recently changed again to 5. But 5 names now go to the governor, and then the governor chooses which one of those persons will get the job. And right now there is one in the hopper. In that hopper right now, there are 5 very qualified individuals who have been vetted through the Judicial Nominating Commission. 5 names came out, and the governor has still a few more days or weeks to make her decision. Regarding the Supreme Court, 3 names also come out, and she would make a decision on that as well. The application form is part of the process. They also ask for writing samples. And then, of course, our interviews are a big part. No matter how good you look on paper, I think it's important and it's correct and it's appropriate for the commission to also look at you and eyeball you and think, what kind of person are you? What would you be like on the bench? What's your demeanor like? I can't imagine a better way to judge that than to have an in-person interview. So that's in a nutshell. what the judicial nominating process is like in the state of Iowa.
Okay. Can you speak at all to a little bit about how judges are retained in Iowa?
Sure. If you're a district court judge, you need to serve at least, I think, at least over a little over 1 year before you're up for retention. So let's say you get appointed in December of 1 year, and there's an election coming up the next November in 11 months. You would not be on the ballot. They give you at least a minimum of 1 year. So you would be on the next time that there's an election. And for district court judges and district associate judges, they have a 6-year term. And for the Supreme Court, we have an 8-year term. I believe Court of Appeals is also 6. Yes. So, and then the retention is the voters are, it's not like Justice Christensen or Justice McDermott, for example, which one should have the spot. That's not what it is. Retention is just my name all by itself, Justice Susan Christensen. Should she stay on as a judge or not? It's a yes or no. It's a thumbs up or a thumbs down. And that's all that is. You don't compete against anyone for that retention. And before a retention occurs, before the vote occurs, we ask the state bar to put out, or we don't ask them, they do it. And Henry probably has more information on that, but they put out something, it's called the Judicial Performance Review. And it gives lawyers a chance to answer some pretty significant questions about the judges that are going to be on the election. For example, knowledge and application of the law. They're asked to rate them on a scale of, I don't know, 1 to 5 or something. And perception of factual issues, attentiveness to evidence and arguments, temperament and demeanor, clarity and quality of written opinions, promptness of rulings. These are all really, really important indicators of how a judge does his or her job. You can see why we give a judge a minimum of 1 year to attain these skills. So I think a review is more accurate. Whether they decide cases on the basis of applicable law and fact, whether they're courteous and patient with litigants. I mean, we are all human, but I appreciate very much that is a quality that is asked of lawyers to review. And another one, that they treat people equally, regardless of race, gender, age, national origin, religion, sexual orientation, socioeconomic status, or disability, and that they demonstrate an awareness of the influence of implicit bias. So that's how the retention works. Once that review is out there for public consumption, of which it is now, that gives voters of Iowa a chance to say, there's going to be 2 people in my district up for retention. I wonder what lawyers think of them or how they're doing. And it's just one more tool to look into before you decide to cast your vote.
Okay. Since you mentioned it, Henry, I'm going to bring you into this. Where can Iowans access the results of the performance evaluation, and how are those evaluations conducted?
Well, you can access it by going to the website of the Iowa State Bar Association. That's www.iowabar.org. And we have a publications link, and you hit that link, and we have, many things available, to and from our 7,400 members, and also available to the public. And one of those links is the Judicial Performance Evaluation. And we've done these every 2 years since approximately 1962. And I know I was on the website last week. I think they go back as far as 1998 on the website.
Okay, great. I'm sorry, go ahead.
Oh, no, and you asked how it's conducted. It's conducted just like the Chief Justice said. We issue our survey to our 7,400 members. We ask that they not rate a judge that they do not know or has not appeared before, and then they give a ranking in those areas that the Chief Justice said from 1 to 5. We compile it without any sort of editorializing, and we make it available. We believe that the lawyers that appear before the judges, regularly have a pretty good view of the judge's temperament, how they treat, pro se litigants, and so it's available to the public.
And this is going to lead me to our first participant question. we often vote on judges, but there's almost never any information or forums about the judges on the ballot. So how can we remedy this and better inform voters who have a say in judicial elections to keep the judiciary fair and balanced? We obviously talked about what the Iowa Bar Association does, but I guess thoughts, I'll throw it to the panel. What more can be done to educate and inform voters about judges that will appear on the ballot?
Well, first of all, I think it's important to remember that this is not a partisan election. As the chief said, this is not an election of pitting one candidate against another. We see that in states across the country and the politicization of the courts. And it's important to remember that the courts are supposed to be the branch of government that are not politicized, that are not political, to the best of their ability. There's always a little bit of politics and everything, right? But for the most part, sorry, Chief, but for the most part, trying to keep politics out of the courts. Why? Why is that important? Because we want fair and impartial courts. If you're going to go into the court, you want to have the best possible chance of winning your case just as much as the person across at the other table, right? And so it is important to keep politics and money and influence out of the courts, and other states do it very differently and have politics in there. So when you're going to fill out the ballot and you have the list of justices and judges on the back of the ballot, you have to think in different terms. It's really kind of unfortunate that we actually do retention on the same ballots that are partisan and have all kinds of electioning kind of stuff happening around them, because you do have to kind of shift gears and think about the judges and justices in a different way. As the chief said, what is their demeanor? How do they handle things on the court? And so if you don't have knowledge of that, going to the survey that the bar does really is the best tool in Iowa. There aren't a lot of other tools to do that. You can certainly have conversation with other people who have had experience in the court and lawyers, those kind of things, but there aren't really other tools in the state that I'm aware of that lay out how a judge or justice is doing in their job. But I do think that not basing your decision just on the media accounts of particular high profile cases, that is probably the most difficult thing to do, is to block some of that out and make a decision based on the things that a judge or a justice should be doing.
And of course, I'm biased. I happen to think our review is the single best source in the state for judges. But also, let's not forget, as the Chief Justice opened with, there's a courthouse in every county, and the courthouses are open to the public. They belong to the public. Now, I'm not sure the COVID restrictions across the state, but when there's no COVID restrictions, everyone's free to go in and observe the operations of the courthouse. It's your courthouse.
Connie, you co-authored a piece in the Des Moines Register with Rachel Caulfield describing Iowa's adoption of the merit selection process as the gold standard of judicial selection. Why is that? And how does Iowa compare to other states?
Sure. And just to clarify, Rachel Payne Caulfield is a professor of political science at Drake University and is one of our state's leading experts on judicial performance, judicial review, pretty much all things judiciary, as that is her field of expertise. So I just wanted to give kudos to her and the work that she does. The courts really at their core are about providing fair and impartial decisions based on the law, right? And the matters that come before them. So regardless of which side you are on the case before the court, are you going to receive fair and legally sound decisions from the court that has not been influenced by politics and political actors and money? And is there, if there is influence on who sits on the bench, how a judge or a justice gets to that position matters. And the system that we have in place cannot be tainted, should not be tainted by politics and by money and by influence. And so Iowa's merit selection and retention process was really initially designed to go a different direction than the state had been using for decades, and to take as much as possible to take politics and to take money and influence out of the process. There is no perfect system, but you can work hard for the courts to be as fair and impartial as possible. And that really has been the North Star of how we have approached things when it has to go around the courts. And until 2010, and we can get more into this, but until 2010, Iowa was the gold standard. And then there was an attack on the courts by some groups that wanted to influence the retention outcome because of one singular decision that was made unanimously by our Supreme Court. And that right-wing group ended up winning that battle in 2010. And so it's an example of when there is undue influence by a particular group because they have a certain political bent or political opinion on a subject matter, how it can do damage to our courts and therefore damage to Iowans' access to the courts as well.
Yeah. So I guess kind of let's get into it since you brought it up. Again, you recently wrote that small changes have imperiled the future of Iowa's justice system, talking about what happened in 2010, and that marked a drastic departure from the norm in Iowa. I guess help refresh our memories. What exactly happened in 2010, and what changes have been made to the state's judicial selection and retention process since then?
So stepping a year back from that, in 2009 was the Varnum decision that gave Iowa marriage equality before we had marriage equality across the country. And that was a unanimous decision authored by then Justice Cady, and who became the Chief Justice later on in his career. And that Varnum decision was highly contentious, and the religious right, and particularly a couple of organizations, were upset by that. And so they launched a campaign in the summer of 2010. There were 3 Supreme Court justices that were up for retention on the November ballot, and those organizations launched a campaign 3 months out to kick those justices essentially off of the court, and were successful in that campaign. So fully politicizing the retention process because of a singular court case, and because they disagreed with it based on their own politics and really also theology as well. So fast forward, there were efforts again in 2012 and 2016 to take justices off of the court in those retention elections. But then the legislature started to get into the fray as well. And so we saw legislation in 2019, and we saw legislation again this past legislative session. So in 2019, they took off the judge off of the state nominating commission and added an extra seat for the governor. So the judge, who is impartial, gave that seat essentially to another appointment to the governor. The governor's at a partisan position, and so really shifting one of the seats on the commission to a partisan appointment. And then in 2022, this past legislative session, we saw several things happening when legislators were unhappy with some things happening in the courts, some attempts for having a hearing and mandating that the chief come and address them, subpoenas. All of that kind of went away and failed, but they did chip away a little bit at keeping the partisanship out of the courts, and did make some changes, attempt to make some changes to the court. The governor vetoed their efforts in part, and she said clearly that she was vetoing it, not because she didn't agree with it, but she didn't think that it went far enough. And so we expect for those efforts to continue. And again, it's the chipping away at the process. And in any institution is never perfect, and should be looked at on a regular basis. But you should have, in our opinion, the stakeholders at the table having a conversation about what's working, what's not working, and how do we make those fixes. And so the court should be part of that. Lawyers should be part of that. Civil rights groups should be part of that. The legislature should be part of that. But to make a conscious decision and conversation about what those changes should be in order to improve things for the courts on behalf of Iowans.
Right. So I guess what effects have those changes, I guess, had on the selection and retentions of judges in the state, and how have those changes impacted Iowans?
I think, and I would ask my colleagues on the panel to weigh in, I think what it mostly has done is impact the confidence of Iowans, the confidence in the courts that Iowans have. I think the judges and justices are doing an excellent job, but when you have this rhetoric coming out of one of the other branches of government or both of the other branches of government, I think that it weighs on the confidence and the trust that the public has when you hear these negative things that are coming out of those branches of government toward the judiciary. And I think that it plays out then on the number of people who apply to be on the judiciary. We've had, as the chief said earlier, lower numbers of people applying because why would folks want to be part of something if it's going to be politicized and they're going to have to go through the ringer kind of thing? So my hope is that we can turn things around, that the legislature can throw its full support behind the judiciary, the governor as well, and to quit politicizing the courts. And if there are things to improve, then let's have a serious conversation where stakeholders come to the table.
So I guess I'll throw it to the rest of the group if they want to weigh in. Henry, I guess, what has your group seen or observed from those changes that Connie described?
Oh, well, like she said, we're seeing fewer people apply for judgeships, attorneys, and I think judges are kind of weary of getting involved. The more and more it looks like it's a political process. I think the fewer and fewer people that you're going to see apply for some of these positions. But with that said, I will say that we have a fair and impartial judiciary. I think when you look at any single judge, and as the chief said, most people are going to have contact at the district court or the district associate court level, and I don't think those judges are bothered by outside influences. I think they have a case before them, they have private litigants before them, and I think they're really just trying to determine the facts, apply the law, and issue a decision that would resolve the dispute. But we will continue to see fewer and fewer people apply if there's this appearance that the process is political. All
right. And then kind of you had mentioned this, that Governor Reynolds earlier this year vetoed a piece of legislation striking down a proposed change to the district court judicial nominating commissions. Republican legislators had inserted a proposal into a judicial appropriations bill. I guess it would have changed who chairs those district court nominating commissions. So each commission currently, and correct me if I'm wrong, has 11 members, 5 appointed by the governor, 5 elected by resident lawyers of the district, and 1 district court judge, the longest serving in the district. And so as it stands now, the district nominating commissions are chaired by the senior district court judge, and the legislation would have had commissioners elect their chair instead, with a senior judge serving on the panel. Is that right?
Yeah, that's it in a nutshell. So the longest serving judge would no longer be automatically chairing and my panel members can correct me if I'm wrong, but my remembrance of that is that it would no longer be mandated that the district judge would chair, but the commissioners themselves would choose the chair. The governor didn't like that because she didn't want the judge to be on the commission at all, because she felt like the judge would have too much influence over the commission, and that's paraphrasing what she said publicly. We strongly believe that the judge has a place. Having a judge on the commissions is important. They bring a perspective that's important. And the folks who are on the nominating commissions are smart, intelligent people. And we don't believe that the judges would have an undue influence over them, and that it's important to include their voice in the process.
And I agree. There'll probably be another proposal this year. And the value and merit of having judges involved in the selection process just can't be overstated. I mean, they're the ones that understand the job. They understand the kind of temperament that's needed. They understand the administrative skills that are needed. I don't think a lot of lawyers and also a lot of lay people understand what exactly are the skills necessary for a judge. And I think a judge is just valuable to that process, and to remove a judge from the process, it would just be a big mistake.
Yeah. At the same time, last year, a former district judge was accused of making disparaging remarks about candidates for a judicial vacancy, which led to Governor Reynolds initially, I guess, rejecting the commission's pick. I guess, what do you say, I guess, to, those who would, I guess, raise concerns about, well, I guess as the governor did, saying that there's serious concerns about undue influence of judges on district court commissions, and again, unconvinced that the proposal she vetoed would lead to any meaningful change.
I'm not sure how many incidents that the executive brought up, but we know we've had this process since 1962. I think, I don't know a lot of facts about that case, but I don't think it's fair to draw conclusions on a process that's been around for 50 years because of one incident. And, things happen, and we have a judicial qualifications commission that can look into any kind of negative behavior on behalf of a judge, whether it's on a bench, whether that judge behaves improperly at the Judicial Selections Committee. We have a process in place, and it's worked. The system's been in place since 1962, and like I said, I'm not familiar with that incident, but that is the one people keep bringing up.
All right. We've got a question from a participant. There seems to be some concerns regarding how partisan Iowa courts have become as a result of whom the governor has appointed to the courts. How can this concern be addressed? And I'll throw it to the group. What should be done to address, I guess, the concern, the perceptions that the process has become more politicized?
Well, we believe by keeping judges in the process, educating the commissioners, keeping politics out of it. That's the best, not politicize the process.
I mean, is that to say that there needs to be legislation reversing changes that were made, or are there particular, I guess, legislative measures, policies that need to be enacted to address some of the concerns that you've brought up today?
Well, our association that represents the 7,400 attorneys in Iowa, but we're on the record as being against all of these encroachments upon Iowa's judicial selection process. Like Ms. Ryan has said, we're the gold standard. We were the envy of so many states, and we're against any kind of tinkering or encroachment by the executive from whatever party upon our judicial selection process. As I started my comments, a fair and impartial judiciary was what was the promise of this new democracy. And we're going to oppose any encroachments that might intrude upon that promise of our democracy.
So I think the courts themselves do a remarkable job, and I want folks to understand that any kind of criticism is not about the judges and justices themselves and the courts themselves, and certainly they have a worldview, or as they sit on the bench, they don't leave things at the door, but the courts do a remarkable job in Iowa of being fair and being impartial.
I'd like to wrap up. I want to touch off of that, what you just said, Connie. And I feel like our court system is very transparent. We're transparent at the level of course, public trials in each of our small communities. In addition, we have something called Court on the Road, which is an opportunity we've been doing, I think, about 10 years or more, going around to different communities. We'll be going to Denison soon, and then Perry yet this term, and not to mention Des Moines. Our appellate hearings are live streamed, and you can also watch them later. We also have our website. The Judicial Nominating Commission has all of their information on a website. You can find all the applications and the writing samples and the interviews. We are doing our best to be transparent. I'm proud of our judicial branch. And I think that we are doing the best we can to make things transparent and to do the best job we can for Iowans.
And if I could add a piece to that, Chief, one of the things that we would love to see in terms of transparency is adding that at the district level too. You all have done a great job at the state level of having the applicant interviews transparent and out there, and we would love to see that at the district level as well. It's a big beast, right, to be able to do that. And so a lot of that has to do with funding from the legislature and having the ability to have staff to do that. So we would love that direction that the courts have taken, particularly at the state level, to go through all levels of the judiciary. And then the other piece that we would argue for is conversations on how to increase the diversity of the applicant pool, increase the number of applicants as well, as Mr. Hamilton was speaking to earlier, but also the diversity and that's a big conversation, probably starting at the high school level, college level, law schools, of having that pipeline of folks who are interested in sitting on the bench eventually. That's lots of different types of diversity as well, race and gender, and what type of practice that they have had as lawyers, and just a variety of things to consider.
So I'm sorry, Henry, were you going to add something?
No, go ahead.
So speaking of diversity, the governor also vetoed a requirement of equal gender representation on nominating commissions. Iowa law stated, I think, no more than half of commissioners appointed will be of the same gender. And then the gender requirements were challenged in May when two plaintiffs argued in a lawsuit that they were functionally kept from running for statewide judicial nominating commission because of the requirement that two commissioners from the same congressional district be at different genders. They argued that the ability to serve on the state judicial nominating commission should be based on their qualifications, not on their gender. And I guess that's a long-winded exposition of getting to a question of how important is it to have that equal gender representation? How important is that in terms of fairness, impartiality, and diversity? I'll throw it to the panel.
It's everything. When you talk, the name of this is keeping balance on the judiciary. And like I can't underscore how fair and impartial our judges are. But when you talk about keeping balance on the judiciary, it's largely a matter of the appointing authority. The judges just accept their positions, and I don't know how much control they have of actually keeping a balance. We have to look at the appointing authority. And it's important to keep that balance. And I think when we say that the court is not balanced, I think we're saying that the court does not reflect the community from which it comes. And I think that's a fair criticism against the system, but not any individual judge. And the reason for this, we have a rich mosaic of diversity in Iowa, and it makes us multidimensional, and it gives us our strength. And people can say, okay, we don't have African Americans, we don't have Latino Americans, and this and that, but that we are all Americans. And it's true, we are all Americans, but we're Americans with different experiences and different backgrounds and different perspectives. And particularly when you talk about the rule of law, those perspectives and backgrounds ought to be valued. I give two statements when I talk about these issues. One is when you talk about the rule of law, what you really mean, or equal access to justice, justice for all, what you really mean is whether you're male, female, black, white, whether your family grew up not owning shoes, your family grew up sharing shoes, or your family only bought the most expensive shoes. Everyone is supposed to be treated equally in front of the law. And I think they are, but sometimes there's that appearance that that's not taking place because the courts may not reflect the community that it serves. And we do need greater perspective in our courts, but we're not alone. And why this is important, and I give a sports analogy. When you watch, Sunday football or a basketball game, and there's a close call, you'll see the referees and umpires go to review the tape, and they're not looking at it from one angle. They're looking at it from several different angles, several different perspectives, and because that call is important. But the issues that we decide within the legal system are just as important, and we also need that varying perspective on our courts. But then again, I just don't know if that's within the purview. And I know the judicial branch has tried through several administrations to bring diversity to the bench, but it's largely going to fall on the appointing authority to appoint a court that more correctly, that more that better reflects the community in which it serves.
Chief, can you speak at all to, I guess, some of the things that the judicial branch has or is doing to try and foster diversity, equity, and inclusion?
Yeah, at my State of the Judiciary just last year, I made reference to a pilot program that we have started. Of course, implicit bias is part of our basic training, and the pilot program has been completed, and we should be launching it soon to all judicial branch employees. But of course, we want to engage everyone in the branch so that not only our own employees, but anybody who walks into our courtrooms or our courthouses and to do business with the judiciary, we want everyone to know that everyone shall be treated fairly, regardless of what background we have or what perception someone may have about our background.
All right. And then, Henry, just to kind of wrap up the discussion on this point, the Bar Association, I understand, is also doing some work in this regard. Can you talk a little bit about what it's doing to try and recruit, retain, and maybe attract kind of a more diverse court or kind of legal workforce?
Yes. And I can say the bar as a whole, and I think as the chief said, judicial branch has been trying for years to create a more welcoming community, socially and professionally for people of different backgrounds. And we haven't met with a lot of success. There's been a lot of good intentions, but there hasn't been the kind of success at most levels that we had hoped for with the resources that have been devoted over the last 20 to 30 years. Well, and I'm happy to announce, I believe, beginning this January, the Iowa State Bar Association will employ a diversity, equity, and inclusiveness officer that can help us in several areas of diversity, take all of these good intentions and see where there could be collaborative efforts to make these efforts more successful. And it holds great promise. And we're very proud of this decision. And this will be open to lawyers, law firms, the two legal schools, and also the judicial branch will be able to use these services of our diversity, equity, and inclusiveness officer.
Okay, great. And then I mentioned this at the beginning, excuse me, but the global pandemic has also impacted how the courts have done business. Chief, can you speak at all as to some of the changes that the court has had to make?
Well, it's kind of a moving target. Of course, when the pandemic first started, we just shut down. We shut down as far as the public was concerned, but the work continued to be there. We had people who were incarcerated who had not yet had their opportunity to have a case before the court. We had child abuse allegations that were being made that normally would, within a very short period of time, have a turnaround from a judge's fingerprint somewhere on a document, whether the child would remain or be removed in the home. We could make those decisions and handle and dispense justice quickly. All of a sudden, we couldn't do any of those things. And so it did catch us flat-footed like it did the rest of the world. I know it did. So first of all and foremost, the first thing we did was we had to keep ourselves safe so that we could continue to conduct business. We had to keep people, children safe. We had to keep people incarcerated safe. And then we started thinking of unique and clever ways to address the legal problems that they don't care about COVID. Legal problems continue to exist. And in fact, many were exacerbated. There were some situations that became worse during the pandemic. So we got better at, and we received some federal funding for some remote things that we could do. We got Zoom accounts like crazy. We started doing as much business as we could, similar to how we are interacting today. Was it perfect? No, but at least it was an effort to try and at least stop the bleeding a little bit. And so then once we got past the worst part of the pandemic, and I consider us to be in pandemic recovery right now, COVID recovery, there's still some issues going on in our world, but we are pretty much able now to function like we did before, but we can't ignore what we learned. And so a committee was started called the Lemonade Committee. And my goal of that committee was, through the pandemic, what did we learn that we need to ditch to the curb immediately? We don't need it anymore. Or is there something we want to keep just as we did it? Or is there something we like the idea and maybe we should probe it a little bit more and modify it? So it's given us, make lemonade out of lemons is why it's called the Lemonade Committee, but it's given us a chance to try things differently. We don't want to shortchange anyone. We want to see if we can provide justice even better than we used to. But I would say, as far as COVID is concerned, our courtrooms are back open. Of course, there might be somebody who is experiencing COVID, maybe a juror has to deal with it, whatever. But we also have jurors that have been picked. A trial's been started. One of the jurors goes home and gets in a car accident. So we have dealt with these types of inconveniences before. We just didn't call it COVID. But I think we're getting better. We will be better after we're keep moving on.
Yeah. So I guess were there some silver linings, so to speak, that came out of the pandemic, and using Zoom or using virtual hearings to kind of maybe help deal with maybe some of the court or case backlog, and realizing that, hey, maybe some of these proceedings we can kind of streamline, maybe be a little more efficient and move it along. Maybe we don't need to have to have kind of the in-person court hearing or experience.
Oh, sure. I mean, for example, in a juvenile case, for example, I would have one case that's closed to the public because it's so confidential. Maybe there's some allegations of sex abuse or something. So you have maybe 3 children, a mom, maybe 2 different dads. There's guardian ad litem. Each parent has a lawyer. The county attorney is represented there. You might have a DHS worker or 2. Maybe one of the children's on probation. You have a JCO officer, and then maybe you have foster parents. Maybe there's the social worker. All of a sudden, you can see how that room that's, quote, confidential to protect the privacy of the child all of a sudden looks like a football game. So there's an example where I think remote testimony or remote participation, perhaps maybe some grandparents live in California, for example. They would have never, ever been able to come to a hearing. And all of a sudden they can be a part of these hearings and watch what's going on. It's especially important in the life of a child. If mom and dad aren't able to figure out a way to keep that home safe for the child, those grandparents watching from afar, even through Zoom, they might be called upon to perhaps be a placement consideration. And if so, if they've been involved in the court system, they are going to be up to speed way better than had they never had anything to do with the proceeding. There's one example. There's other examples. And I'm just asking our judges, use your discretion. This is no different than if Henry was an attorney in Des Moines and I was an attorney in Harlan, and we were on a case together, opposite sides. And maybe the issue was just a discovery legal issue, whether or not something should come in or not. Henry might have in the old days filed something called a motion to appear telephonically. That was completely normal. And a judge would look at it and say, yeah, Mr. Hamilton lives in Des Moines. We're just going to be discussing legal issues. There's not going to be any testimony. I think he should participate by phone. And more than likely, I would have said, I don't object. That's fine. This isn't much different than that. We need to use our brains, don't check them out at the door, and figure out what cases make sense to get done economically for our clients, expeditiously for the court system. But there are times where we need to be in the seat, in the chair, in front of the judge. So I'm just asking judges to use their discretion and let's use technology, but never to a point where it abuses a person's right to have a different type of hearing.
All right, sounds great. Well, that is our time. I'd like to thank our panelists and our audience for attending, and remind the audience members to go to iowaideas.com and check out the schedule. We have coming up tomorrow, which includes featured keynote speaker, Michelle Shelton, as well as closing keynote speakers, Clarissa Chun and Dan Gable, and many more panel discussions and topics coming up tomorrow as well. So please go to iowaideas.com and check out the schedule. Again, thank you very much to our panelists. We really appreciate you taking the time and participating.
You bet. Thank you.
Thank you for allowing us to discuss this important subject.
Very welcome.